I'll go over. All right, who are the parties on Adrian Arias?
President, Your Honor. Ryan is the prosecutor.
Are you able to take it through?
Can you walk me through, Judge?
Yeah.
I don't know if we're going on lesser included or.
Oh, I will walk you through it, but we're waiting for his client anyway.
Okay.
He's present.
Oh, let's bring it up. All right, the court is calling 2020 CR 12347, State of Texas versus Adrian Arias. Could I have parties announced for the record
Michael,
for the state,
Michael Villarreal for the state.
for the defense?
Martin Guerra.
And are you Adrian Arias?
Yes, ma'am.
Mr. Arias, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement.
Yeah.
Have you, just a moment, the state hasn't really. Have you received all of the discovery in this case and did you review it with your client?
Yes, sir.
All right, the court will find that the state is in compliance with discovery. Mr. Arias, I'm showing you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, it appears that you are proceeding on the lesser included offense of deadly conduct and you're waiving counts 2 and counts 3. Is that correct?
Yes, Your Honor.
Any objections?
No objections.
Mr. Arias, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that the state is proceeding on the lesser included offense of deadly conduct from count 1? The range of punishment for that offense is anywhere from 2 to 10 years. Yes. Is it all? Okay. The range of punishment for that offense is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Arias, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney and did you understand it?
Yes, ma'am.
All right, so everyone, I'm gonna need you all to speak up so it's easy for Brenda to hear. Okay. All right, according to the plea bargain agreement, the state is proceeding on count 1, but they're proceeding on the lesser included offense of count 1, which is deadly conduct. They're asking that your fine be assessed at $500. The state recommends deferred adjudication. This is to run concurrent with County Court Cause number 6600924. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargaining agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with Joseph Freeman, Freeman, Alexis Herrera, and Victoria Hernandez, and no possession of firearms. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense of deadly conduct, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state up for state's exhibit number 1 as attachments.
No objections.
Mr. Arias, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty of deadly conduct. However, the court will defer finding of guilt as you apply for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Respectfully, Your Honor, we're asking you to follow the plea bargain agreement. Mr. Arias is really anxious to get this case behind him. He's got some long-term goals, not just his job. He just recently got a new job, but he really wants to try and complete this as fast as possible.
All right, Mr. Arias, what do you do for a living?
Flooring and tile, wood flooring.
Are you good at it? If I see some of your work, I'm not going to see any rippling or buckling.
No, ma'am, I received a raise on my first day and even a bonus on my first check.
When do you remove the flooring or do you just lay it on top of?
Removed.
Do you leave dirt behind? You know, some people, they'll remove the baseboards and then just whatever, if people had something to drink, they just shove it in there and just seal it up. Do you do that?
Absolutely not, ma'am.
Okay. I'm just asking for a friend. Do you have any children?
Yes, I do.
What are their ages?
21 and 17.
Okay. So if you're drug tested today, what are the results going to be? And before you answer, you are going to get drug tested today.
I'm completely honest about everything, ma'am. I pride myself on that. And I would come out there,
All right, for what?
marijuana and methamphetamine.
Okay, all right, how often are you using that?
Methamphetamines a few times a week, marijuana less than that.
Okay, all right, so we're gonna test you today, but it's for us to get a baseline, but you're gonna have to stop using, you understand?
Yes, ma'am.
And I'm going to give you the help that you need. I'm not gonna start him off with intensive, I'll start him off with outpatient treatment, we'll see how it goes from there. All right, thank you for your honesty. A lot of people, they say no, and then when they find out they're gonna get drug tested, then they say, well, in all honesty. So I appreciate you having your, in all honesty up front. You're welcome. All right, this is what the court is gonna do. Court is gonna sentence you to a $500 fine. That'll be probated. This is to run concurrent with County Court Cause number 60924. 4 years deferred adjudication. 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get it, but if you do, 40 of those hours will be waived. But I want outpatient treatment with probation. We're going to do a UA today. And Rebecca, that's just for us to get a baseline on everything. There should be no contact with the following persons: Joseph Freeman, Alexis Herrera, Victoria Hernandez, no firearm possession, that goes without saying. We're going to do field visits, random. Rebecca, we'll start off with 1 time per month. Since do you have any minor children that live with you, or you have a girlfriend who has minor children?
No, ma'am.
All right, we're going to start off random random field visits 1 time per month. There should be regular reporting by Zoom or in person. So if you can't report by Zoom, you need to make sure it's done in person. You understand?
Yes, ma'am.
And we'll do random UAs or the patch. Proof of employment within 30 days. There should be no employment as a home health care provider with minors. We're also going to do anger management. And once you complete the anger management, that will take care of the remainder of your community service hours. Rebecca, is there anything else that he needs? Okay. You're shaking your head now.
No, I'm sorry, I couldn't reach the unmute button.
All right. Mr. Arias, is there anything else you need from the court in order to be successful?
No, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we got the record, Mr. Arias. So many things could have went wrong. You understand?
I'm sorry, I missed that, Your Honor.
I said so many things could have went wrong with this night or this day. So make sure that you hold on your temper. I always tell people, no matter what's said, what somebody says to you, even when it comes to writing a response, just hit pause. You know, pause, think about it, come back the next day. Of course, then it may become premeditated, but hit the pause button. All right, probation is going to go over conditions with him. She's in the back.
Thank you.
All right, good luck to you, Mr. Arias.
Thank you, Your Honor.
All right. Is Della Rosa, the attorney for Della Rosa here?
I'm here, ma'am.
The attorney is not. But the defendant is. All right, thank you. Mr. Della Rosa, we're just waiting for your attorney to zoom back in.
Yes,
and then
ma'am.
we'll
Thank
take
you.
up your matter.
Yes, ma'am. Thank you, ma'am.
Thank you. All right, who's here on David Thomas Rodriguez? You're David Thomas Rodriguez?
Yes, ma'am.
We're just waiting for your attorney. Thank you. And anyone else who is ready, you need to take the file from the clerk and they will put it up here and I will call you.
Thank you. I've been to take a look, so I'm just waiting for his copy.
Okay, thank you.
And I'm just waiting for my admission.
All right, thank you. Oh, yeah, sure, but just put that, yeah. at the bottom. All right, here, who is here for Rudolph Montoya?
Michael Gross for Mr. Montoya, Your Honor.
All right, and is Mr. Montoya on bond or in custody?
He's in custody, Your Honor.
Okay, is he-
My bag's back. He's not here yet.
okay, all right, as soon as he comes up, we'll check it out. And we'll wait for Alexis Morganfield. Is Alexis Morganfield on bond?
He is, Your Honor.
All right, where's Mr. Morganfield?
I spoke with him this morning. He is attempting to get here, Your Honor.
Okay. All right, who are the parties on Richard
Lockett.
Lockett? Is it Lockett? Can you pronounce his name?
Lockett, L.A.
So you say Lockett?
Lockett.
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 Good afternoon, Your Honor.
All right, we should have just done the L-O-C-K-E, but okay. Now that I know, I'll remember to say Lockett. All right, the court is calling 2022 CR 2350, State of Texas versus Richard Lockett. Can I have parties announced for the record for the state,
Brian Grimmer for the state of Texas.
for the defense?
For Mr. Lockett.
And are you Mr. Lockett? All right, Mr. Lockett, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it? I'm gonna need you to speak up so the court reporter can hear.
Yes.
Let's act like we're outside, you know, so
Okay,
screaming at children. All right,
you got it.
Brenna, when you shout at a child that's about to run across the street.
I didn't hear it.
That's what they say, what? All right, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case and did you review it with your client?
I did, Your Honor, and I have, yes.
Court will find that the state is in compliance with discovery. Mr. Lockett, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, I did.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We're not, Judge. We're proceeding on our lesser included offense. We'd ask the court, we're going to reduce it to a Class A misdemeanor DWI second.
We have no objection.
Okay. Do y'all want to change this on the paperwork?
It does, Judge.
Just so it'll be clear for everyone.
Of course.
All right, and defense, you have no objection to proceeding as a DWI second?
We have no objection, Your Honor.
I'm hoping that's the lowest spot, Judge.
Off the record for a moment. Rick. Excuse me. Do you have this stamp? That's okay. All right, Mr. Lockett, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, I did.
All right, do you understand that the state is proceeding on the less included offense of driving while intoxicated second? The range of punishment for that offense is up to 180 days in the Bexar County Jail and up to I'm sorry, up to 1 year in the Bath County Jail and up to a $4,000 fine. The state is proceeding on it as a Class A misdemeanor. Did you understand that to be the
Yes,
range
I
of
did.
punishment?
Yes, I did.
All right, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, I did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, I did.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, I did.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes,
Counsel, has your client been able to provide you with any defenses to this offense?
he has done.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Lockett, has anyone threatened you, coerced you, or placed you in fear to get you into this plea?
No.
Has anyone promised you anything other than the plea bargain agreement?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Are you a U.S. citizen?
Yes. Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney and did you understand it?
Yes, I do.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of driving while intoxicated second. They're asking that your punishment be assessed at 1 year in the Bear County Jail. There'll be a $500 fine and the state recommends community supervision. Did you understand that to be the plea bargain agreement?
Yes, I do.
Defense, is that the plea bargain agreement?
It is right.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I do.
Counsel, have there been any such motions?
No, no, ma'am.
Next, I'm showing you outside the plea bargain agreement. The state is recommending that your community supervision be for a term of 1 year. There be a TAP evaluation, DWI intervention, DIP live, and an admission interlock for half the term. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, I did.
State, are you recommending license suspension?
Judge, we talked about that with the, whatever is mandatory. I do not believe he's ever taken the defensive driving. And so whatever is mandatory on a DWI second, if he hadn't taken the defensive driving, then he is eligible to take that course, and we're asking the court to authorize him to take that course.
State,
Judge, I'm not aware of a statutory one. I'll defer to the prosecutor who prepared the paperwork. I'll be honest, I don't know.
I don't think it's statutory, Judge, if you take the course.
what there is jail time.
That can be probated, Your Honor.
3 days.
Yes. Which is a standard. Honestly, I'm not aware of any judge in Bear County who does not probate the 72 hours.
Oh, I mean, I'm not saying that I'm going to give him 3 years, but I'm saying that that's part of the statutory requirement. I know it's been forever since I've been in misdemeanor court. So let me just review the DWI second. I know he can get a driver's license suspension, and I'm just looking at the law. Just give me 1 second.
Yes, ma'am.
Because we're off the record for that.
Okay.
Because I know for a fact that there's also a fee that's associated with GPS.
On a conviction, there is a fee and there's an enhanced, and that's why we agreed to waive the enhancement.
Okay.
But yeah, there is a fee that's assessed through DPS super fine.
Yes.
The court can waive that on a affidavit of indigency, has the authority to waive that. He's probably innocent.
Well, with regards to the indigency, I am aware of the law that, and my understanding of the law on that is that needs to be declared at the time of sentencing. Because if it's not done at the time of sentencing, then he's out of luck.
I think he would be happy to make a declaration of indigency at this time.
All right, so, okay, so we're back on the record. Do you understand, Mr. Lockett, that your license can be suspended for up to 2 years? And that there is a requirement of 3 days jail, 3 days in the Bexar County Jail as a condition. Do you understand that? I need you to understand that. I'm not saying that I am going to require that, but I need you to know that that's part of the law. Do you understand that?
Yes, I do.
All right. Then to the offense of DWI second, how do you plead guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
Yes, Judge, State will offer State's Exhibit number 1 and all attachments.
We've reviewed, Sam, Judge, we have no objection.
All right, Mr. Lockett, I'm going to show you what's entitled waiver and consent for stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it
Yes,
in
I
all
did.
the appropriate places?
Yes, I did. Your Honor.
Again, did you understand you have a right to jury trial? A right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent.
Yes, I do.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Right, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. All right, Mr. Barrera, is there anything you would like to put on the record in regards to your client or call him as a witness?
I would just like the record to reflect that, and the evidence presented by the state in that package reflects that his first DWI was in 1980. He was granted deferred adjudication. He successfully completed his 1-year probation. He had a second run-in with law enforcement in 1987, approximately 15 years ago. To my knowledge, he successfully completed that probation. He has, to my knowledge, been alcohol-free since the date of this incident, and be an excellent candidate for the probation judge. And do you, Mr. Lockett, have the funds to pay the super fine of $3,000 in that regard? Do you state to the court that you are indigent?
I do. Yes, I do.
That's all I have.
Oh. And Mr. Barrera, you may want to check to see if that's enough. I will find that he's indigent, but you may also need to
We'll
send an
supplement with
affidavit.
affidavit of indigency, Judge. I'm aware there is one, and we'll supplement the records with that.
All right.
Thank you, Your Honor.
All right, Mr. Lockett, are you employed?
Yes, Your Honor.
What do you do?
I'm a certified cremator.
A certified cremator. All right, well,
It's a
Brenda,
dead-end
I'm just
job.
giving all sorts of information for things I may need in the future, hopefully in the far, far away future. So why has the price of cremations gone up?
That's gas.
So you just do standard cremation or do you have the liquid cremation as well?
It's cremated. We just get the permit for the state and we cremate.
Okay, you know, Brenda, my biggest fear is that, and I don't know why I have this fear and I probably shouldn't have. Do you clean them after each use? Like if somebody were to go in there, their ashes would mix with someone else's.
No, I mean.
So
I couldn't hear your question.
yeah, there's no chance, let's say you
Okay.
cremate someone.
Right.
And do you clean it right after? Is there a chance that some ashes are going to get mixed?
Oh, no, there's a procedure for all that stuff. Yeah, so, our job on the line, we cannot make mistakes. So we gotta follow the procedure real tight.
Okay, Mr. Barrera, you seem very interested in this too, whether or not the ashes will be mixed.
I've just heard horror stories, Judge, about what goes on with that cremation and that the remains are not totally burned. They're subsequently crushed and mixed in.
Well, my understanding is that there is some bone, but they say with the liquid cremation, everything goes away. All right. So as previously stated, the court is finding you guilty. The court will sentence you to 1 year in the Bexar County Jail, suspended and probated for 1 year. There will be 3 days in the Bexar County Jail. That will be due to COVID.
Be what I'm sorry.
I said, due to COVID, I'm not going to have you do the 3 days in the Bexar County Jail, but he is going to have to do GPS for 3 days.
Understood. Thank you, Judge.
And that three-day GPS, that means that you're going to be at your house for 3 days. It's like you're in lockdown. Now, if you have to go to work, then it's going to be more than 3 days. So will you have to work or can you take 3 days?
Well, I'm gonna have to request for those 3 days.
Okay, so that'll be a full GPS for 3 days.
I mean, we select those dates with probation, Your Honor. in order to
Yes.
get Hooked up and
Proof of employment within 15 days. There should be no employment as a home health care provider with minors. There should be regular reporting in person or by Zoom. There's a $500 fine that'll be probated. DWI intervention. GIP live. Admission interlock for half the term. Defensive driving. And there should be regular UAs. Rebecca, is there anything else that he needs?
Judge, were you gonna do field visit?
Yes, so we're gonna do field visits 1 time per month, regular field visits. All right, Mr. Lockett, is there anything else you need from the court in order to be successful?
Well, Your Honor, the last time I had my DUI, it was dispensary, but it was 30 years ago, about 25 years ago. I took a wrong drink at the wrong time and I got arrested, but I got my granddaughter gonna graduate from my UTSA. She's going for her bachelor and she's going for the master, but I want to be here for her. She lived with us and she's going to college, and she's want to be a doctor, and my drinking's over. I just,
Okay, awesome. I teach at UTSA.
you,
Yes.
she's going.
All right. Okay, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, I do.
Right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do.
All right, good luck to you. No more drinking.
You got it.
All right, thank
Thank you,
you.
Your Honor.
Probation will see you in the back. And everyone, just give me a moment, please.
Good afternoon. Have a good afternoon, Your Honor.
Oh, thank you so much. You too. Miguel Nahara, are you ready on your case, Mr. De La Rosa?
I am.
Ma'am.
All right, the court is going to call 2022 CR 3521, State of Texas versus Armando De La Rosa. Can I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the
Miguel
defense.
Nahara for the defense.
And are you Mr. De La Rosa?
Nothing to do with me.
Yes, ma'am, I am.
All right, we're proceeding by video for Mr. De La Rosa. He's accompanied Mr. De La Rosa.
Yes,
Showing you
ma'am.
what's entitled defendant's consent to appear by video. Did you review that with your attorney? Did you understand it and did you electronically sign it?
Yes, ma'am, I did.
Court will find that defendant has knowingly and voluntarily consented to appear by video.
Yes, ma'am.
Defense, do you have any objections?
I already been locked up on my life.
No objections, Judge.
State any objection.
None, Judge.
Mr. De La Rosa, I'm
And
sure
then they wanna play,
for deferred education or community supervision.
just as
You review that document with your attorney, did you
get me locked
understand
up
it?
again.
Yes, I have, ma'am. Yes, I have.
Counsel, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I did, Your Honor.
Court will find that the state is in compliance with discovery. Mr. De La Rosa, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, I have, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, we do have a couple of clarifications, Judge. There's 2 counts on there. We proceed on count 1, waive count 2, and then also waive the repeat offender enhancement.
So
No
proceed on
objections,
count
Judge.
1. Waive count 2. Sorry. And waive repeater.
Yes, Judge.
Any objection?
Yeah.
None whatsoever, Judge.
Bogus.
All right, so Mr. De La Rosa,
Where's mine?
Yes, ma'am.
so it's easy for us to hear on this
Or
end.
anything like that.
I'm gonna ask that you mute yourself until I ask you a question. If there's something you need to say, just unmute and that way we can keep everything up. Because there's some noise coming from your end.
Thank you, ma'am. Sorry about that.
No problem. Mr. De La Rosa, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am, I did. And yes, I did understand everything and did sign it in all appropriate places, ma'am.
All right, did you understand in count 1, you're charged with possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams. That's a first-degree felony. The range of punishment is anywhere from 5 to 99 years or life in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am, I do.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and give you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am, I did.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am, I did.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, ma'am, I did.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am, I do.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could sentence you up to life in prison and up to a $10,000 fine? Did you understand?
Yes, ma'am, I do.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. De La Rosa, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am, they haven't.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am, no one.
Are you satisfied with the way you've been represented?
Yes, ma'am, I have.
Are you a U.S. citizen?
Yes, ma'am, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea bargain agreement, the state is proceeding on count 1. Punishment is to be assessed at 10 years in prison. There's a $1,500 fine. The state opposes your application. The state will take in consideration 2022 CR 2011 and 2022 CR 2012. Did you understand that to be the plea bargain agreement?
Yes, ma'am, I did.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you electronically sign it in both places?
Yes, I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, I did.
Counsel, have there been any such motions?
None have been filed, Your Honor.
Then to the offense in count one of the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, ma'am.
State, any evidence?
Yes, Judge. State would offer State's Exhibit number 1 and all attachments.
No objections, Judge.
Mr. De La Rosa, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, I did, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, I did, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am, I do.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. After reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding you guilty as you've applied for deferred adjudication. Ms. Ferguson, do you have a date to come back for sentencing? All right, we're going to come back on May 25th for sentencing. Mr. Nahara, do you expect to have witnesses?
It's a potential, Judge. I've talked to my client about it. I don't know for certain at this time.
All right, State, are you anticipating on having any witnesses?
I don't think so, Judge. I don't think we'd have witnesses, just argument.
All right, so Mr. Nahara, we're going to set it at 9 a.m., but if it turns out you have more than one witness, let us know because it may be moved to 2 p.m.
Understood, Judge. May 29th at 9 a.m.
May
25th. I'm sorry, that was my fault.
Yes. Okay. July 25th?
According to Rebecca, they're so far behind. They're asking for everything to be set mid to end of July.
So it will be July 25th. They're telling me, Mr. Nahara, because of the
Ooh,
backlog.
Okay, understood, Judge. I'm sure my client would just appreciate the earliest date possible, and that's July 25th. That's what it is.
All right, so it will be July 25th at 9 a.m. And are you requesting a TAP evaluation, Mr. Nahara?
I think that would be appropriate in this case, Judge.
All right, and that will be with the TAP evaluation, Rebecca. All right, I'll send you all to a breakout room to speak with probation, and Mr. Nahara, you may go to a breakout room or you may be excused.
I'm going to go for a little bit, Judge. May I excuse myself from there?
Yes.
Lovely flowers, Judge. Have a wonderful day.
Oh, thank you. Have a great day too. And I'm not even a mom. Well, just to my students, so. All right, who is the person on Isaiah Salinas? Okay, so we'll wait for Mr. McCray then. Who are the parties on Arias? Adrian Arias. All right, bottom of the pile. Okay, we'll just put them to the bottom of the pile. And when they come back, we'll pick it up. Joe Ardilla.
Yes, Judge.
All right. All right, the court is calling 2022 CR 3329, State of Texas versus Joe Anthony Ardilla. Can I have parties announced for the record for the state,
Ryan Grimmer for the state of Texas.
for the defense?
Marshall B. White, Your Honor.
And are you Mr. Ardilla?
Yes, I am, Your Honor.
Is there an application in this case? or
No, it's not, Your Honor.
Okay. Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Ardilla, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Judge, we're going to waive the repeat enhancement allegation on the indictment.
Any objections?
No, Your Honor.
Mr. Ardilla, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, Your Honor.
Do you understand you're charged with the offense of felon in possession of a firearm? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargaining agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor. I do.
Did you understand by entering this plea bargaining agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargaining agreement in this case?
Correct, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Ardilla, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your
Has
Honor.
anyone promised you anything other than the plea bargaining agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor, I am.
Are you a U.S. citizen?
Yes, I am, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishments to be assessed at 2 years in the prison. There are no applications. Did you understand that to be the plea bargain
Yes,
agreement?
Your Honor, I do.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
It is, Judge.
Next, I'm showing you a paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
There have not.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence.
State would offer State's Exhibit number 1.
Any objections?
No objection, Your Honor.
Mr. Ardilla, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, I did, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding to sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Judge, respectfully, I ask the court to follow the agreement that Mr. Ardilla entered into with the state of Texas.
All right, Mr. Ardilla, I'm sending you to 2 years in the prison. Give you credit for any time served.
Thank you, Your Honor.
You're welcome. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, I did, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, I do, Your Honor.
And also because this is a felony conviction, which you now know, if you didn't know before, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, I do, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, I do, Your Honor.
All right, we can go off the record. Mr. Ardilla, good luck to you.
Thank you, Your
How
Honor.
old are you?
I'm 54 years old, Your Honor.
Okay, it's time to stop the madness, you know?
Yes, I do, Your Honor, and I greatly appreciate you and your time.
All right, good luck to you.
Thank you.
All right, who is on Tavon, Washington? All right, you approach, please. Court is calling 2021 CR 8724, State of Texas versus Tavon, Washington. Deputy, is there any way to uncuff him so he can pull up his hands?
Please.
Yeah, just give us a, we're gonna take care of that, Mr. Washington.
Thank you, Your Honor.
Oh, you're welcome.
What's the name of the last one?
Ardilla. I know I'm mispronouncing it because I'm not rolling the R's.
Is it on the Lockett?
Yes, that I can't answer you.
Okay.
Brenda, that's a question that
I
cannot
know.
be answered. All right, the court is calling 2021 CR 8724, State of Texas versus Tavon, Washington. Can I have parties announced for the record?
Ryan Gerber for the state of Texas.
Kathy Compton for Mr. Washington.
And are you Tavon, Washington? All right, defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, I have.
Court will find that the state is in compliance with discovery. Mr. Washington, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, we do.
All right, it appears that the state is proceeding on the indictment as presented. Is that correct, Ms.
That's
Compton?
my understanding, yes.
Yeah, that's a phone. And that's where we look, and the person whose phone is ringing, you look around, or is it the exit sign, because it's flashing? Deputy Laura, is there is not. Okay, I'm being told that is not an emergency. Oh, where's the influencer going? Mr. Stevenson?
Your Honor.
Your client has left the building.
Just gotta bring it back.
All right, thank you, Mr. Stevenson. Okay. Mr. Washington, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, you're charged with the offense of aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement, it gives you more than you bargained for. The fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Do you understand?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Absolutely, yes.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Washington, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. There's a $500 fine, affirmative finding of deadly weapon, and no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Or sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the plea.
Yes, Judge. David Offer State's Exhibit number 1.
Any objections?
No objection.
Mr. Washington, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation, testimony, and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will find you guilty. Are we proceeding with sentencing?
We're asking to do that, Your Honor.
Anything you wish to say on behalf of your client?
I would just ask the court to follow the plea bargain agreement.
Okay, what happened?
Probably about the worst day of his life. There was, I think it was just a lot of things that with Tavon that kind of just came to a terrible head that day. And he's very remorseful. He's, you know, he wants to just move on and put this behind him. He's never been in any serious trouble before now, although the conduct itself obviously was very, very serious. He has spent enough time now in jail to where I believe that he just wants to be able to move on and live his better life. And I don't think you will ever see him here again. I think that he will be finished with this and move on to be a very productive person in society. He's a very intelligent young man. I think that he just made some really poor decisions that day. And unfortunately, it's one of those things where there have to be consequences. We understand that, but I do think that that's why the state offered the minimum sentence in this case.
And how much time does he have in custody?
How much time? do you have?
11 months.
Yeah, so he's well on his way to finishing it up, Judge.
All right, then I'll sentence you to 2 years in the prison. There's an affirmative finding of damage weapon, give you credit for any time served. I'm going to show you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, Mr. Washington, good luck to you.
Thank you.
All right,
Have a blessed day.
all right, you too. All right, who are the parties on Hannah Smith?
I'm present, Judge.
All right, if you will approach, please. All right, court is calling 2021 CR 2127, State of Texas versus Hannah Marie Smith. Could I have parties announced for the record for the state,
Brian Bremer for the state of Texas.
for the defense?
Monica Guerrero for Ms. Smith.
All right, defense has filed a motion asking that the defendant's bond be reinstated. State, are you ready to proceed?
Yes, Judge.
Just so we're clear, some things happened. I think I remember this. Ms. Smith was not supposed to be driving. Ms. Smith, I believe, was behaving inappropriately and was asked to come to court. The court had no idea that Ms. Smith had been driving for who knows how long. And Ms. Smith drove to court, but she was in a vehicle on Zoom, and then she drove to court. So that's where we are. So Ms. Herrera.
And on that day that she came to court, apparently her retained attorney withdrew. And then I was appointed to represent her.
Yes.
So I haven't had this case very long. However, the court remanded her without bond on that day, and she's been in custody since. Her family is extremely supportive. They sold her vehicle so she wouldn't have a car anymore. Her employers contacted me, her boyfriend's contacted me, civic leaders have contacted me, her mother has contacted me. They all want her to get back out so that she can go back to work and show the court what she's done. She's been in 12-step programs. She has not had any positive UAs. She tells me that, you know, she's been doing everything that the court has asked her to do, and that she was unaware that Ms. Corley had filed an affidavit of non-driving. She had been blowing into an in-home device, and she would like very much to be placed with a bond so that her family can make her bond. That if she has a vehicle, that she will put ignition interlock in there. But as of right now, her mother has told me they have sold the vehicle and they no longer have anything for her to drive. Her bond was set at $50,000 in inception.
Well, even though Ms. Corley did an affidavit of non-driving, people in this court who are on DWI, I always let them know and have them present when someone is doing an affidavit of non-driving, because I tell everyone that they need ignition interlock, and they say, oh, they're not driving. And I say, well, they need to provide an affidavit of non-driving. My concern is she filed an affidavit of non-driving. Obviously, her signature is on it because it's an affidavit of non-driving, and yet she drove to court and she didn't have ignition interlock.
Judge, if I may, obviously, Judge, I was going to bring up my recollection of that day was the same as yours. I did want you to take judicial notice because I know you were on the Zoom that day. You know, if there is an affidavit of non-driving on file, I mean, I presume that she signed it and that, you know, she was aware that she wasn't supposed to be driving. Regarding the indictment in this case, it's a very serious charge, among the most serious charges you can get involving a vehicle. And that's why we believe it's important, Judge, to not take it lightly, the fact that she said she wasn't driving and then she was for sure driving that day that we see her on Zoom driving. We can presume that she was driving on other days if she thought she was just free to drive. The state would ask for her bond, if you grant her a bond, for it to be doubled to 100,000 along with full GPS house arrest.
I'm still trying to figure out why should I grant her a bond when and mind you, Ms. Smith, I don't take any of the facts of these cases true because I haven't heard any facts. But what I have is you're charged with intoxication manslaughter. You did an affidavit saying that you would not be driving, and yet you were driving, which means you were driving without ignition interlock, and you're charged with intoxication manslaughter. The number one rule when you have any intoxication offense, if you're doing an affidavit of non-driving, you don't drive. If you're driving, you have to have you have to have ignition interlock. So I'm not going to reinstate the bond. You're remanded without bond.
I'm sorry, I forgot that I had signed the paper and wasn't driving for that long. I'm really, really sorry. I have been doing so good and I want to continue to do good.
But you knew you were driving without ignition interlock. But if you want to give testimony, I will swear you in. You want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Hannah Marie Smith.
All right, Ms. Guerrero, do you want to do question and answer, or you just want her to state?
I just want her to talk.
All right.
I did not, I was not aware. I do remember signing the paper, but I was not aware that I was not supposed to be driving at all. I did tell Miss Linda Corley, I called and I had spoke to Roland. And I had told Roland, he didn't tell me anything about getting the interlock or calling pre-trial. There's something about I was supposed to have called pre-trial. I was never told any of that. I would have done it. I have done everything that I have been told to do. I would have done it. I'm in IOP, I'm in precision recovery. I went to an inpatient program. I have a sponsor. I worked a 12-step program. I go to AA meetings. I go to see Rick Green regularly Tuesday and Thursday night. I fully participate. I bottled back on my mental health medication. Being in the IOP program has put me, I have found out that I have hyperthyroid and Graves' disease, which I wasn't aware of until I had gone into the IOP program. I mentally and physically, everything about me has gotten so much better. This past year to year and a half, I'm really sorry. The car is gone. You can take my license. You can revoke my license. You can do whatever. I'm not gonna drive anymore. I take the bus. I'm trying. I tried really hard for a whole year. I'm sorry.
State, any questions?
Nothing specific, Judge. I would just like the court to be aware, or just obviously, Judge, I mean, I think it's concerning that she's signing things, and the biggest concern we have whenever someone commits a crime with their vehicle is they're going to do it again, and she's not even aware of conditions that are part of her probation, or I'm sorry, part of her pretrial.
All right, and the court notes that there is a previous pretrial violation, Ms. Guerrero, for hijack reading, but at that time, the court did not issue a judge's warrant or remand her without bond. But you knew you were not supposed to be driving, and yet you did it anyway. And you drove without ignition interlock. And again, we go back to the fact, I don't take it as true, but you're charged with intoxication manslaughter. So the motion to reinstate the bond is denied.
Will the court consider any bond?
Denied this time. If you want to speak with the state and see if the state would be in agreement for a bond, but at this time, no. Ms. Ferguson, this is, the setting date on this is May 16th. Ms.
Correct,
Guerrero.
it's next week.
Okay.
May I be excused?
Yes,
Should you have a seat over there? I can talk to her?
yes. All right, is the person here on David Thomas Rodriguez?
Oh, Judge, I'm here, Your Honor. Thank you.
Yes.
Um,
Just one moment.
okay.
Can I have the white noise, please? And could you place me on mute? Fine.
Thank you so much,
Okay,
Judge.
so Ms. Ferguson. She is now back on him instead of coming tomorrow.
Yes, ma'am. Thank you.
So my understanding that offer has been tendered, so if I can have a 30-day reset on David Rodriguez. All right, we'll come back on June 20th.
Okay, Judge, thank you so much. I mean, I kind of did want to try to just get it done today, you know, it's better.
No problem. If you do that too,
Thank
let me
you
know
so
that
much.
have
Okay.
it. Rudolph Montoya.
Michael Gross.
All right, this is for a bond hearing.
It is, Judge.
All right, have you conferred with the state or not?
I have not, but free trial on the back of their form for the violation said either keep the bond the same in full house arrest or increase the bond full house arrest. My request to you, Judge, respectfully, is keep the bond the same and go back to full house arrest.
Okay, so we're here for a violation report, correct?
There is a violation report, yes, Your Honor.
All right, and so on that violation report, I issued a judge's warrant and remanded him without bond.
You did on 28 April.
Okay, so this is family violence.
It is, Judge.
Right. Is there someone available on family violence? Have you all talked to Mr. Gross about Rudolph Montoya?
I have not, Judge.
It's a bond matter. He's been remanded without bond because of the new offense, and he's actually remanded without bond. Is he still remanded without bond out of Travis County or no?
I'm sorry, Judge.
Is he still remanded without bond out of Travis County or no?
No, he made the $3,500 bond in Travis County on the DWI first.
All right, so, you're welcome. So if you confer with the state and see if you all have an agreement on the bond amount, defense is stating they're willing for him to be on full GPS.
Okay, if you just give me a couple moments, Judge, I'll hopefully
Thank
we'll come
you.
with an agreement.
Thank you, Judge.
You're welcome. All right, just sit on the.
Yes, ma'am.
All right, who are the parties on Adrian Rodriguez? Okay. All right, the court is calling 2020 CR 4135, State of Texas versus Adrian Rodriguez. Can I have parties announced for the record for the state,
Ryan Brewer for the state of Texas.
for the defense?
Albert Gutierrez.
And are you Adrian Rodriguez?
Yes, ma'am.
I keep wanting to say we're proceeding by video because I have the video here. All right. Council, I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Rodriguez, I'm going to show you what's entitled true bill of indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor, and have one question for Mr. Rubin.
Yeah.
Yeah, okay. Yes, we waive the reading.
State, are you proceeding on an indictment as presented?
We're not, Judge. What we're actually doing, Judge, is proceeding on I guess, a lesser included offense of assault, aggravated assault causing SBI. And it is also a second-degree felony. However, we're adding the SBI language and taking out the deadly weapon language.
All right, any objection?
No objections to that amendment.
All right, Mr. Rodriguez, I'm going to show you what's entitled court admonishment and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Do you understand the state is proceeding on the less included offense of aggravated assault causing serious bodily injury as a second-degree felony? The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, he is.
Mr. Rodriguez, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on the less included offense of aggravated assault causing serious bodily injury. They're asking that your punishment be assessed at 2 years in the prison. They're taking in consideration 2021 CR 11709, 2021 CR 11708, County Court Cause number 63793. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that document? I'm sorry, did you review that paragraph with your attorney? Did you understand it and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Off the record for a moment, Rebecca, there's no application.
Thank you, Judge.
Counsel, have there been any, back on the record, counsel, have there been any such motions?
None heard, Your Honor.
Okay. Then, Mr. Rodriguez, how do you plead to the less included offense for aggravated assault causing serious bodily injury? Guilty, not guilty, and no contest?
Guilty.
State any evidence to support the defendant's guilty plea?
Yes, Judge. State would offer State's Exhibit number 1.
No objection.
Mr. Rodriguez, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you have a chance to review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. Off the record, Mr. Rodriguez, Ross,
Yes, Judge.
County Court 13 said they'll take your plea this afternoon.
We've been there for about an hour, Judge, and they haven't.
Okay, did you contact Sybil?
She's been on the screen, Judge.
Okay. Check on that. Okay. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am. Yes,
Anything
sir.
you wish to say on behalf of your client?
Yeah, we think this is a good plea bargain. There's, I mean, you may have seen some of the facts, but these parties were known to each other, and it was just something that escalated on both sides, Judge, and so we think that this is a fair way of resolving this, and we'd ask for you to accept the plea bargain and sentence him to 2 years.
All right, anything you wish to say, Mr. Rodriguez?
No,
You sure?
just thank you for the deal.
Okay. All right, the court will find you guilty of the aggravated assault causing serious bodily injury. The court will follow your plea bargain agreement and sentence you to 2 years in the prison. Give you credit for any time served. Take in consideration the following cause numbers: 2021 CR 11709, 2021 CR 11708, and county court cause number 637-923. Is there anything else from either side with regards to sentencing?
Nothing further.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to your attorney. Do you understand?
Yes, ma'am.
All right, good luck to you.
All right, thank
Vehicles
you.
are for driving on roads. You understand?
Yes, ma'am.
All right, this is for you, Mr. Gutierrez. All right, who are the parties on Luke Cantu? Yes.
Need to go pick up a child. Maybe we have a plea worked out.
Who's your case?
David Perez.
All right, have you finished all the paperwork?
I have not finished the paperwork. The state's finishing up their end of it right now.
Okay. And what's the name?
David Perez.
All right, Ms. Ferguson. We're gonna call Mr. David Perez back for tomorrow.
And I don't have anything else tomorrow, so I'll come straight to you.
Okay, thank you.
Thank you, Judge.
Judge, just want to let you know we have an agreement on Montoya's bond.
All right, if you can just type that up for me, or either write down what the agreement is. Yes, just, you can have the court print the B page and write the agreement.
Yes, sir.
All right, who are the parties on Luke Matthew Cantu? Is this criminal trial division or family law?
It's with me.
Oh, no, take your time. I know you're a person of one. Let's give us a moment. Mr. Gutierrez, I used to have a backpack, and you know, people would always laugh about my backpack, but I never had any back problems.
Yeah, I tell you what, Judge, I was concerned about the look. I said, well, I don't know, is it professional enough? I bought it to go on spring break for my daughter's senior trip, and I wanted all my computers and everything safe. But after the trip, I said, in March, I said, well, I care what everybody thinks.
Well, you know what?
It feels good, it carries everything nicely, all my cords, everything I need. I said,
My mom said, be a leader, not a follower. So I was the first person who was wearing backpack, and they're like, who is that child with a backpack? You can tell I've aged since then. I'm like, who's the child? But she got me a backpack for like almost every color. And that's when you would have to carry around the heavy books.
Oh, yeah.
And every defense attorney could, I look at your code, like, damn, get your own.
Well, what I'm gonna do is, I'm gonna say, I'm almost a leader, but I follow Judge Boyd.
Okay. All right, have a good one.
Thanks, Judge.
All right, Judge.
All right, the court is calling 2021 CR 8085A, State of Texas versus Luke Matthew Cantu. Do I have parties announced for the record for the state?
Ryan Groomer for the state of Texas.
James Murat for defendant Luke Cantu.
And are you Mr. Cantu?
Yes, Your Honor.
All right, Mr. Cantu, on April 5th, you entered a plea of no contest. According to the plea bargaining agreement, punishment is to be assessed at a cap of 10 years in the prison. There's a $1,500 fine, and the state opposes your application for community supervision or deferred adjudication. This is to run concurrent with 2021 CR 8083. There are several cases that are being taken into consideration, and there's to be no contact with James Glenn, GLEN, and Jacob Noble, NOBLE. Are both parties ready to proceed with sentencing?
Yes, Judge.
Yes.
All right, state you're opposed.
Yes, Judge. Judge, we just have argument, Judge.
All right, defense, do you have any witnesses?
No, Your Honor.
All right, then we'll proceed, state with your argument, and then Mr. Byron will proceed with you afterwards.
Judge, the biggest thing I'd call your attention to, Judge, is his criminal history, Judge. Mr. Cantu, almost every single offense he has picked up has been something involving stealing from someone else. It dates back to 2009. He's never been successful on probation ever in terms of his felony offenses. And in addition, he has been to prison before for the exact same thing that we're here today. Judge, at some point, he just can't stop stealing. He's been to prison for 7 years for burglary. And here we are back again with more thefts. In this particular case, we have 3 thefts. We're asking for 10 years because last time he did 7 years on a burg. And that wasn't able to reform his conduct. We believe that 10 is appropriate based on his criminal history and the facts of these cases.
All right, and I'm assuming both parties have had a chance to review the PSI report?
Yes.
State?
Yes, Judge.
All right, Mr. Meyer?
So, yeah, much of what the state has highlighted concerning Mr. Cantu's criminal history is accurate. He does have a lot of property crimes, theft crimes, burglary crimes, and seems that it's just been trailing him since the last 14, 15 years, with a trip in the pen and a trip in the state jail. What's different now is he's 37. I think he's come to the realization that, well, I think when you look at property crimes don't happen without a reason. They happen because they're being fueled by some serious drug use. I mean,
But sometimes, isn't that just a person's occupation? My occupation is I steal. When people go to work, I break into homes. That's my occupation.
No, that's not his occupation. His occupation is, well, in fact, what happened in this instance, he was actually working, sending out flyers door to door to hotel rooms for pizza coupons, I believe. And he found an opportunity where some doors were not secured, entered into hotel rooms, taking items, pawning them off. And there was not a whole lot of police and resources necessary to find that he had been linked to the burglary. He was actually very forthcoming and cooperated with detectives and police to essentially turn himself in without too much trouble. But no, to answer the question, his occupation is not a thief. His occupation is a person who's trying and needing to get help to rehabilitate his very bad, very serious drug dependency problems. We're talking about, gee, ecstasy, cocaine, and meth, heroin daily. If granted the probation, we certainly, Mr. Cantu is seeking inpatient help and treatment at the state facility to get rehabilitated, to seek drug treatment. He's, I think, admittedly thinks that at this time, maybe he's not ready for engagement for release at home or anything. I think he understands that. But I think he does not need, admittedly, I think in his PSI as well as his TAP eval, he was very honest and about that he does need patient help. But yeah, no, I mean, I think property crimes is a byproduct or the result of serious drug dependence problems.
I mean, sometimes it is, sometimes it's not. Sometimes that's what people do for a living, because it's easier to break into homes and break into places as opposed to getting a job. That's why you have some people who burglarize in the daytime, because they know other people are at work. But Mr. Cantu, what have you learned? Because you had a theft case in 2007, and you were placed on deferred adjudication for 12 months. Why did you commit that theft?
Because I was in my addiction at the time and I wasn't ready for any kind of rehabilitation. Man.
So they gave you deferred adjudication and you didn't follow through, because I'm sure that when they gave you deferred adjudication, they offered you drug treatment.
Not that I'm aware of, no ma'am.
All right, so then in 2008, you were placed on probation for 2 years for theft, 500 to 1,500. What did you learn on that probation?
Nothing, Your Honor. Again, I was in my addiction at the time using drugs. I've been using drugs almost for about 15 years. And I think that's been my letdown in my fallback in society is my drug habit. It's something that I know that I need to work on. And I kind of give up.
2009, you committed evading detention. You did jail time. That was February. June 2009, you had a resisting arrest, search and transportation, you did jail time. You also had an evading detention. February 22, the resisting arrest being taken into consideration. Then on April 14, 2009, you were given deferred adjudication for theft under $1,500 enhanced. And I know that you were probably offered drug treatment. So when you're on deferred adjudication or on probation and you have a drug problem, because they do DUAs on a regular basis.
Yes, ma'am.
So did you take advantage of drug treatment then?
No, ma'am. I think what I needed at the time was some kind of inpatient intensive treatment.
Did you ask for it?
Yes, ma'am, I sure did.
And I'm sure if you asked for it, they would have given it to you.
I did ask for it, and it's something I wasn't granted, but it's something that I need. I know I do need inpatient treatment, something that I need to.
All right, then we have March 2012, burglar habitation for 7 years. April 2012, and I'm assuming all of these were running concurrent because it's all 7 years. So you had burglary with intent to commit theft, a separate case. So those two were run concurrently. And now we're here for more thefts, burglary habitation fourth and thefts. I don't think there's anything that I can do to help you. What I can do is I'm going to deny your application, but they do have a therapeutic community at the prison. And if you want help, they can give you help. However, if you don't ask for it, me requesting it is not going to mean anything. I can't force them to put you in the therapeutic community, but if you request it and I request it, then they may put you into it. Do you understand?
Yes, ma'am.
All right, so I'm going to deny your application. So punishment is a cap of 10 years. State you're asking for 10.
Yes, Judge.
Mr. Meyer, what are you requesting?
Well, I'm requesting obviously lower than the 10. Look, I think we need to just focus on Mr. Cantu's rehabilitation, and if there is an opportunity that he can rehabilitate in a TDC facility, giving him tools and skills to overcome drug addiction, we ask the court make a sentence in which that would allow for the period in which he can get that help in the TDC facility. So therefore, I'm asking for a sentence between 2 to 10, but of course in the court's discretion.
Mr. Cantu, what do you think you deserve?
I deserve whatever it is that you feel you need to do with me, Your Honor. I know I've done a lot of wrong in life. I understand that, and I'm ready to the point to where I'm tired. Even when I was out there in my addiction, Your Honor, I was tired, but it was just so hard for me to get out because I was so far into being a heroin addict and a drug user that I couldn't find myself to find any kind of treatment, to find myself any kind of help at the time. I was just so far into my addiction. So whatever you feel is appropriate for me, then that's what I have to do, Your Honor.
All right, then the court is finding you guilty. The court will sentence you to a $1,500 fine, time and money to run concurrent. I'll request for you a therapeutic community. This is run concurrent with 2021 CR 8083, taking consideration 2021 CR 8070. County Court Cause number 678886, NIMAG number 649008, CM number 96156. There's to be no contact with James Glenn and Jacob Noble. I'll send you to 8 years in the prison, and of course you'll receive credit for any time served. Mr. Cantu, when you're released from prison, I always know that people have plans, right? When they get out of jail, when they're placed on probation, they say they're going to do everything and get their life in order. But what I've seen in my short time on the planet, even though I'm old, I consider it a short time on the planet, is that sometimes those ideals fly out the window. But when you're released from prison, the first thing you need to do is you need to get in touch with someone to help you with your drug addiction. And usually when you release from prison, sometimes they'll send you to a halfway house to help you with that. You need to make sure that you take advantage of that, okay?
Yes, ma'am.
All right, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Oh, and also in 2021 CR 8083, I'll sentence you to 8 years in the prison, credit for any time served, the therapeutic community, $1,500 fine, time and money to run concurrent. And this is to run concurrent with 2021 CR 8085A. All right, why does this say run concurrent with 2000 CR 85? No, this is running concurrent, 2021 CR 8085A. It says it's running concurrent with that. That was an A? Yes. All right, concurrent with 2021 CR 8085A, taking consideration 2021 CR 8070, County Court Cause number 67886, NIMAG number 649008, CM number 96156. And this cause number as well, I'm going to show you what's entitled well, as soon as I have it, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. He's not in here. Ah. Mr. Cantu, did you review what's entitled trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because each of these cause numbers are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, Your Honor.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Cantu. I wish the best for you.
Thank you.
You're welcome. All right, who are the parties on Michael Campos? Are you on Michael Campos?
Yes, ma'am.
What is happening with Mr. Campos?
It's, we've
Oh,
been not,
there's a bar right there, like that line.
I'm sorry.
Thank you. Yes.
We've got an offer. So first setting, I'd like to get some time.
Okay, where's Mr. Campos?
Michael.
Do you have all the discovery?
I believe so.
All right, Ms. Ferguson, on Michael Campos, can I have a 30-day reset, please? All right, we're gonna come back on May 20th. June 20th.
June 20th.
June 20th. That's what I'm being told. At 9 a.m. And that will be your plea deadline date, Mr. Campos. So you receive the state's offer. You need to let the court know on that date whether or not you're accepting that offer. Do you understand?
Yes, ma'am.
All right, they're gonna give you a reset form.
Appreciate it.
You're welcome. Who is on Michael Marine? Michael Anthony?
You mean Michael Martin?
Martin, yes, Michael Martin.
That's mine. So Judge, it's actually down as a first setting. I'm appointed. He has a plethora of cases in Medina County.
I'm saying plethora like the Three Amigos.
Like a piñata, yes. So I texted Christian Newman. He's over there now in the DA's office. And we're gonna see if we can work out some sort of package to encompass the cases here and the cases there, because they're exact same cases. So I texted Christian about 20 minutes ago. He's gonna get in contact with Ryan. We're just asking for a 30 days so we can try to get everything worked out at one time.
Okay.
Yep, that's what we're gonna do, Judge. I think a couple of weeks ago, we worked out one with Christian here in our court too, so it's convenient having him there.
Okay, so we'll bring this one back on June 20th, Ms. Ferguson. All right, so Michael Martin, June 20th, but make sure you get a reset form. All right, who are the parties on Jeremy Rotheny?
That's me, Judge. That's a thing from a trial we did, I think back in March.
Okay, how many witnesses do you have?
None. State doesn't have any either, Judge.
Okay, where's Mr. Rotheny?
In the box, Judge.
All right, the court is calling 2019 CR 3013, State of Texas versus Jeremy Ray Rotheny. Can I have parties announced for the record for the state?
Michelle Hayden for the state.
For the defense?
Robert Mauer for the defendant, Your Honor.
And are you Mr. Rotheny?
Yes, ma'am.
All right, we're here for sentencing. You received a guilty verdict from the jury. Have both parties had a chance to review the PSI report?
Yes, Your Honor.
We have, Judge.
Any objections to the PSI report from either side?
No, Your Honor.
No, Your Honor.
All right, state.
Your Honor, we don't have any witnesses. We just have argument. We'll reserve.
All right, defense, I'll hear your argument then.
Judge, I'm sure the court remembers this trial. I was frankly stunned that any jury in Bexar County would have convicted Mr. Rotheny on the facts and the testimony that was put in front of it. Both with the testimony from the complainant that contrasted with the testimony from her own mom, The detective, I think, did a poor job working the case up and presented the evidence. I think the court should take that into consideration when assessing punishment. Of course, it doesn't matter what I think, that he was convicted by a jury, but the court recalls, I think there were a lot of issues with what we had as far as the jury deliberations that led me to believe that somebody had made it onto the jury through some sort of deception. And I would ask the court to sentence Mr. Rotheny to 2 years GDC based upon the facts of the case. As the court recalled, the allegation was a one-time touch over the clothes while the mom was out partying with her friends. And that was the entire case. Mr. Rotheny's prior criminal history involves, I think, some state jail time for theft. So, Judge, I would ask the court to take that in consideration when assessing punishment. And I would ask the court to sentence him to 2 years TDC since he is not eligible for probation.
All right, State.
Your Honor, defense seems to have a different recollection of the case than I do. The court heard the testimony of Angelina Straub, Christina Bigler, Eric Mata, and Detective Stokel. I thought Angelina and her mother both came across as very credible and still very affected by what happened to Angelina that night. Now let's talk about the defendant's criminal history. Defense says that he did some state jail time for theft, but he actually did more than that. So in 2016, he spent 13 months in a state jail facility for taking someone's car that did not belong to him. In 2017, he was confined for 12 months for another theft in Comal County. And in 2019, he was sentenced to 4 years in prison when he screwed up his probation again on a case where he'd taken someone's property that did not belong to him. So the defendant has a bad habit of taking things and touching things and people when he shouldn't. Let's talk about this case. He continues to show no remorse and makes no apology for what he's done. And defense may have their opinion about the trial, but the fact of the matter is a jury did find him guilty of the indecency with a child by contact. Now, Angelina had to wait 4 years. That is a long time in the life of the child. She had to stand in front of this court and be re-victimized. It was clear when she walked into the courtroom and started testifying that she was still very much affected by what the defendant did to her. And think about how frightened she was that night when she texted her mom. He violated this family in the worst way possible. Christina Bigler thought she met someone who cared about her and her kids, someone that she could trust, someone that would help her. Think about what it was like for her to get those text messages that night, how terrifying that must have been. And she can't be here today because her child is sick, but you heard from them in the trial. We're asking you to sentence to the defendant to 11 years in prison so that for the next 11 years or the remainder of his sentence, he can think every day about how he's not supposed to touch children. 12 months wasn't enough. 13 months wasn't enough. 4 years wasn't enough for him to learn to be a better person. Give him 11 years, 1 year for each year of Angelina's life at the time he molested her. Let that be a daily reminder to him that what he did was wrong, and we are going to hold him accountable. And that when you decide to touch a child's vagina, it's going to be taken seriously and you will be punished.
All right, Mr. Rotheny. The court will sentence you to 8 years in the prison. Give you credit for any time served. And there should be Chapter 62 registration, that's lifetime registration. Do you understand? I'm sorry.
Yes, ma'am.
All right, I'm going to show you what's entitled. I'm sorry, is there anything else on either side with regards to sentencing?
No, Judge.
No, Your Honor.
All right, Mr. Rotheny, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
All right, you have a right to an appeal since this is a jury trial. You understand?
Yes, ma'am.
Mr. Mauer, if you're not going to.
I filed a motion for new trial. But I think I didn't need to withdraw and have the appellate public defenders. I'm not sure if I can handle the motion for new trial because I actually also filed a motion for the court to disclose the juror information so I could have an investigator look into whether or not anybody on the jury gave false information or testimony during voir dire. But I'm not sure if the court wants me to do that or just withdraw and let the appellate defender's office do it.
It's however you wish to proceed, Mr. Mauer, but you'll need to let Ms. Ferguson know, and if you're planning on withdrawing and he's planning on asking for appeal, then of course that needs to be done as quickly as possible.
I've got the motion for new
before
trial
30
filed
days.
already. We'll file the notice of appeal as well.
All right, thank you. All right, are the parties ready on Marla Garrison? Good luck, Mr. Rotheny. All right, what are we doing sentencing?
Yeah, restitution's already been completed, Your Honor. It has, Judge. So I believe in the sentencing document, we said that we would not oppose a motion for new trial from the state's perspective if they did it. They provided upfront restitution, so we are complete in that regard. I guess we just wanted to know, do you want Mr. Acevedo to file something?
Or are you going to have any objections?
I don't have
to
any
it so
objections.
orally?
No.
All right, the court is calling 2020 CR 6716, State of Texas versus Marla Garrison. Could I have parties announced for the record for the state,
Ryan Drummer for the state of Texas.
for the defense?
Alberto Tost for the third, Your Honor.
All right, and are you Miss Garrison? Yes, ma'am. All right, according to the plea bargain that was entered, if the defendant were to pay off the restitution, then the state agreed that the defense could file a motion for a new trial. The reason why this was allowed is because it appears that it was taking a long time for Ms. Garrison to pay off the restitution. So has she completed the entirety of the restitution?
Yes, she has, Judge.
Okay. And what are you requesting?
Judge, we're requesting that you grant a motion for new trial in this case, as agreed upon in our plea bargain agreement with the state. That was agreed on, Judge, and as we agreed, we don't have any objection to that request.
All right, motion for new trial is granted.
Judge, we have a dismissal office. That was, the agreement was that.
All right, Ms. Garrison, good luck to you. We're off the record. I was wondering if you were going to make it back with the.
I was running. I was coming.
All right, you have a great rest of your day.
You too, sweetie.
Thank you, Judge. You have a good day.
Thank you much.
You have a good day, Judge.
Thank you. My name's not Sweetie.
Thank you.
All right, thank you. That's okay. I appreciate it. I'm sure it's a term of big deal. All right, who are the parties on Adam Andrus?
Andres Adame, Judge?
Yes.
That's me.
I think one of the indictments under Adam Andres and the other's under Andres.
Yes, so we have two.
Yes, ma'am.
All right, the court is calling 2019 CR 8465 and 2020 CR 5634, State of Texas versus Andres Adame. Could I have parties announced for the record for the state,
Michelle Hayden for the state.
for the defense?
Robert Mauer for defendant, Your Honor.
And are you Mr. Adame?
Yes, ma'am.
Defense, and each of these cause numbers I'm showing you what's entitled discovery acknowledgement. Have you received all the discovery in each of these cause numbers, and did you review it with your client?
I did, and yes, I have.
And each of the cause numbers, the court will find that the state is in compliance with discovery. And each of the cause numbers, Mr. Adame, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, ma'am.
Counsel, each of the cause numbers, do you waive the reading of the indictment?
I do, Your Honor.
Stating cause number 2019 CR 8465, are you proceeding on an indictment as presented?
No, on that one, we're waiving the repeater count and proceeding on the lesser included offense of aggravated assault with a deadly weapon.
Any objection?
No, Your Honor.
And in cause number 2020 CR 5634, are you proceeding on the indictment as presented?
Yes, Your Honor.
Are there any applications in?
No.
Mr. Adami, and each of these cause numbers, I'm going to show you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them?
Yes, sir.
In cause number 2019 CR 8465, the state is proceeding on the lesser included offense of aggravated assault with a deadly weapon. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, sir.
And cause number 2020 CR 5634, you're charged with the offense of felon in possession of a firearm. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison. Did you understand? And up to $10,000 fine.
Yes, ma'am.
And each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargaining agreement. If for any reason the court does not follow your plea bargaining agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand?
Yes, ma'am.
Did you understand by entering these plea bargain agreements, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, sir.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
He has.
In each of the cause numbers, do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
In each of the cause numbers, do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Adama, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
In each of the cause numbers, are you satisfied with the way you've been represented?
Yes, ma'am.
In each of the cause numbers, are you a U.S. citizen?
Yes.
In each of the cause numbers, I'm showing you what's entitled plea bargain pages. Did you review those pages with your attorney? Did you understand them?
Yes, Your Honor.
In cause number 2019 CR 8465, according to the plea bargain agreement, state is proceeding on the lesser included offense of aggravated assault with a deadly weapon. Punishment is to be assessed at 4 years in the prison. There's an affirmative finding of deadly weapon. This is run concurrent with 2020 CR 5634. There's an affirmative finding of family violence. You'll receive credit for any time served, which I must give you. There's to be no contact with Angela Bexar, Becerra, or Alex Bexar, Becerra. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, sir.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, sir.
In cause number 2020 CR 5634, according to the agreement, punishment is to be assessed at 7 years in the prison. There's a $1,500 fine. There's no applications, and this is run concurrent with 2019 CR 8465. Did you understand that to be the plea bargain agreement?
Yes, sir.
Defense, is that the plea bargain agreement in each of the cause numbers?
It is, Judge.
State, is that the plea bargain agreement in each?
Yes,
of the
Your
cause
Honor.
numbers? In each of the cause numbers, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, Your Honor.
Then in cause number 2019 CR 8465, how do you plead? Guilty, not guilty, or no contest to the offense for aggravated assault with a deadly weapon?
No contest.
And in cause number 2020 CR 5634, I'm sorry, 5634, how do you plead? Guilty, not guilty, or no contest?
No contest.
All right, and if I didn't say it before, the court is finding that the defendant has knowingly and voluntarily waived his right to jury trial. And state, do you have any evidence to support the defendant's plea in each cause number?
State offer States Exhibit 1 that's attachments to the evidence.
You have no objections, Judge. on either one.
Mr. Adami, in each of the cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? And did you sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept them to evidence States Exhibits 1 and attachments and review the same. right, in each of the cause numbers, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, I just asked the court to follow the plea bargain. I think we worked it out in the appropriate manner after going through all the evidence.
All right, in cause number 2020. Court will sentence you to 7 years in the prison. Give you credit for any time served. There's a $1,500 fine. Time and money to run concurrent. This is run concurrent with 2019 CR 8465. And cause number 2019 CR 8465. Court finds you guilty of aggravated assault with a deadly weapon. Court will sentence you to 40 years in the prison. Give you credit for any time served. There's an affirmative finding of a deadly weapon. An affirmative finding of family violence. There's to be no contact with Angela, with Sarah, or Alex, with Sarah. And this will run concurrent with 2020 CR 5634. In each of the cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review those documents with your attorney? Did you understand them? And did you sign them?
Yes, ma'am.
And cause number 2020 CR 5634, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
And cause number 2019 CR 8465, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because there is an affirmative finding of family violence, and also because it's a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you. And be
you,
sure to
Judge.
stay away from those people that are listed as complainants.
Judge, we do have victim impact. Marina's just gonna read it.
All right, thank you. All right, there's going to be victim impact. Just internalize what's being said, Mr. Adami.
Okay, so this was written by Angela. She sent it to me, so these are her words. Andy, you would always say you love me, but I just wanted to tell you, why would you hurt me like you did? When you shoot me, you don't call that love. My life is never going to be the same. For your action, I have to deal with all these issues, from having anxiety, depression, and then I question myself, like, why would you do this to me? Same thing over and over. And not only that, now I'm dealing with having seizures like your Aunt Tina. I never know when I will get them. A few times Alyssa and Trey were sitting next to me, so imagine what they were going through when they see me. They're going through a seizure, and a lot of time, I can't remember things. My doctor said it can get worse. I hate you so much, Andy. I swear I do. You really messed me up. Now I have to suffer for your actions for the rest of my life. And I don't think it's fair that you get a little bit of time that they're giving you. You're not the one that has to suffer through what I'm going through right now for the rest of my life. I don't think it's right. I will never forgive you, and I will hate you for the rest of my life.
Thank you. All right, Ms. Roach, your motion has been signed.
Judge.
Yes, I've signed the order.
Oh, you did?
Yes.
Okay. A quick question logistically on it. So does that reinstate our bond? In other words, we don't have to go get a new bondsman on that large bond, right?
So there's no objection to reinstating the bond?
Not that I'm aware of.
No, Your
Honor.
It just-
as long as the condition of full house arrest is.
All right, can you look and see if he's outside the window of opportunity just to reinstate that? So it will depend on how much time has elapsed, on whether or not. can be reinstated. I have no problem reinstating it, but if too much time has elapsed, it can't be reinstated.
Understood.
All right.
Is that something I can call the court
Oh,
later
they're
on?
gonna check for it right now.
Oh,
Yes. Never put off for tomorrow what you can do today. All right, who are the parties on Jonathan Garcia? Oh. Yes. Yes.
Judge, I've conferred with Mr. Rumor. He's new to this case. It's still a trial case at this point. If we're gonna try it, Judge, my only concern is we have an expert appointed from Dallas, Dr. Timothy Proctor. He's a mitigation expert. It's the main issue in the case. And so I just kind of know when you want to try it. There's still a chance we could work it out, but it'd have to come from administration. We have agreed, our prosecutors have agreed on stuff, but administration thinks differently.
I don't, Ernie's kind of filled me in a little bit more about the history of the case. Sounds like we need to get I think he needs to figure out, I think right now we need to just assume it's going to be a trial, but me and him are working on it with the information he's given me. I don't know enough to tell the court one way or another, but we're going to keep working on it.
So when will the state know something?
Well, I think right now, Judge, my understanding is it may have gone up to admin before and they said no. So I almost think we should just get a setting to find out when when his expert is available and then find out when the trial is going to be. I don't know. That's more on Ernie's end, but I don't know if I will have a different answer than Tom previously got from that administration.
Okay, has it already been up to administration?
Yes.
All right, so, and we need to set this for jury trial. Ms. Ferguson? Are both parties here at the end of this month or beginning of next month? Because that's when it's gonna be set. It's either gonna be set at the end of this month or the beginning of next month. Because this is an old case.
Yeah, it is an old case, Judge. I probably need to get it at least in the middle of June or early July. And Dr. Proctor is, he's our appointed expert judge, and we just don't have a date. I'll have to make sure he's available because
All right, he needs to be subpoenaed, because this is an old case. So I can either put it at the end of May or the beginning of June. The latest I will hold this over will be June 13th.
Judge, I'll email Dr. Proctor when I get back to the office. I mean, I really don't want to threaten to arrest him if he's got trial schedules. I mean, he's been appointed on the case for 3 years, Judge. And I mean, he did tell me, just give me some time and I will put you on my calendar and I will book it. So I'm just asking for a little bit of consideration for the doctor because he is our main witness. He is our main witness.
All right, tell him his dates are May 31st, June 6th, or June 13th.
I can do the 21st.
Well, his dates are May 31st or June 6th.
And if he's booked on those days, Judge?
He's not. Why are you putting that in the universe?
I mean, Judge, I've
You
done with
put
it.
that out in the
I mean,
universe. We'll cross that bridge when we come to it. Okay, reinstate it with the same conditions that are on there.
Did I luck out, Judge?
Yes.
I
you
did. Clean living. Thanks, Judge.
You're
May we be
welcome.
excused?
Maybe yes, there
Welcome.
already. I've talked about it.
Thank
Maybe.
June 13th. I'm sorry, not June 13th. You said you can do June 13th, right? Garcia. All right, so then it will be June 6th.
There's only one day to check off. June 6th is the only day to check off. There's got
Well,
one
June
option.
6th or either May 31st.
Or May 31st.
Yeah. So I figure I'd put you out as far as possible.
All right, I will email him.
All right, thank you. And where is Mr. Jonathan Garcia?
He's downstairs.
Okay. All right, so we can go back. So we'll be back on June 6th. All right, who's on Jason Brown?
I am Judge.
Yes.
Just real quick.
Yes.
I am new to this case. I just got hired. I provided Ryan an affidavit. This is a really simple case. And so I provided an affidavit from the owner of the vehicle and the owner of the gun, who was in the vehicle at the time of the stop, that he was in possession. I just gave it to Ryan today. I was going to ask the court if you can give us maybe 30 days so we can try to see what we can figure out about this. There's an unindicted case that's been pending for a long time. And we're going to try to see if we can figure everything out at one time.
What is the unindicted case?
I don't know. Yeah. What? I think, let me find it, Judge. Okay. There's a, looks like either a drug charge or another felon possession charge. They're from their night mags. They seem to have been pending for a long time. I don't know if they're waiting for labs or what's going on.
What is the full charge? What level?
So I see on the night mags, I see a possession with intent to deliver 400, a felon in possession, and a marijuana 4 ounces to 5 pounds. I don't know why they're not. I don't know the reason for them not being indicted. The offense date, it looks like for all three is July 30th of last year, June 30th, no, July 30th of last year.
All right, Ms. Ferguson, on Mr. Brown, can we put this?
I'm coming back on that June 20th. Can we do the June 20th docket? I've got the other person set.
Are we able to put this for June 20th, Ms. Ferguson? All right, so June 20th will be your trial date.
Thank you, Judge.
And Ms. Ferguson, that's Jason Brown.
Thank you.
Sure. All right, who are the parties on Isaiah Salinas? We said that one already. Why do I have this? It's oh, that's the other one. Yes.
Oh,
All right, we'll figure it out.
sorry, Judge. I didn't know this had a warrant.
Okay, we'll see what happens.
That was with Todd McRae.
Yes. All right, Maxwell Jordan. And then after that, we're gonna do Alexis Morganville. Yes, what is happening with Maxwell Jordan?
Maxwell Jordan was that writ of habeas corpus that was agreed relief that we're still waiting on the Court of Criminal Appeals to decide.
Okay, do you have any idea, some sort of time frame on that? I know I'm asking you to get in the minds of several people.
So here's what I'll say. If we don't get a decision before the end of this month, they basically go on hiatus for the summer and it'll be the fall.
All right. Remember on Maxwell Jordan? Let's recall it for the end of June. Let's see what's happening. We can have a date? Okay. All right, we'll come back on June 30th. All right, thank you. Yes. Oh, I'm sorry. Yes, one more.
There was one other case that I had filed a motion for judicial clemency on, and I'm not asking you to rule on that today, but I was wondering if you'd be amenable to setting that for a hearing sometime.
Oh, sure. Just speak to the court about, speak to the coordinator about saying that.
Will do. Thank you.
Yes.
On Roy Wilmer, Your Honor, I just got back from County Court 13. They cannot do it today, but
Okay.
we're set for Zoom Thursday. I've already accepted the offer.
And that's this Thursday?
That's this Thursday, Judge.
All right, can I see the file on Wimber? And what we'll do is we'll recall this then on May 12th.
Yes, Your Honor.
And you can go there first and then come back here.
Yes, Judge.
And where's Miss Wilmer?
She's still in 13 because I didn't know what was gonna happen if I came up
Okay.
here, Judge.
All right, what I'm gonna do is, if you'll get a reset form
Yes, Your
here,
Honor.
and just take it down there and bring it up.
Yes,
to
Your
me.
Honor. I'll do that again, Judge.
Do I have the file on Wilmer? All right, Ms. Ferguson, if you give him a reset form on Lori Wilmer for June 12th. And he's gonna, I'm sorry, May 12th.
No.
May 12th, and he's gonna go downstairs and then give her the reset form.
I'm not gonna bring you back up here. We didn't know what.
All right, Alexis Morganville.
Thank you, Your Honor.
You're welcome. Thanks for being patient.
Yes, Your Honor. I have provided, you had asked me to have all of my documentation in order. I do with an index, and I can give it a copy of this to Michael Villarreal with the state. May I approach you, Your Honor?
Yes.
And give you a copy of the same thing I just gave the state.
Okay, sure. All right, Mr. Villarreal, before we go on the record, have you had a chance to review the exhibit?
I've previously reviewed these documents. We have no objection to the state review, or for them to write back. They're admitted for purpose of this hearing.
Your Honor, I can sum
Oh,
these.
Just 1 second.
I do apologize.
All right, no problem. Court is calling 2021 CR 1805, 2021 CR 1804, 2020 CR 5024A, and 2020 CR 3637, State of Texas versus Alexis Morganville.
Your Honor,
Where's your client?
the proceedings today apply to.
No, where's your client?
My client is seated. Would you like my client to come up
Yes.
and stand beside me?
Yes.
I will. Here.
All right, so
The
it's the court's understanding is that Mr. Morganville was arrested out of county. The court
When, Your Honor.
issued a judge's warrant and remanded him without bond. And my understanding was, yeah, I got a pretrial violation report. And he was out of county. He was arrested. Well, he was arrested by another county and he had to go to that other county. Am I wrong in that?
That is not
I
correct.
believe
Your Honor.
it's an out-of-county warrant
Yes, Your Honor.
for an offense that predated.
But
The
did
offense
the
that-
out of county pick him up?
No, I believe he was arrested here in San Antonio.
Okay,
That is
arrested here.
Yes, sir.
And then did he make bond on the out of county issue?
Yes, he has made bond on that case.
But he
Okay.
has not attended court in Williamson County yet.
All right.
I can clarify, Your Honor, if the court will allow, and I will.
I mean, I
go-
read your
Okay.
documents. So it's the court's understanding that no violation actually occurred while he was on bond for this court with this court's commission?
So he technically picked up a new possession case, but it was rejected at the magistrate. At the time of his arrest, I believe that's my understanding.
The dismissal for that possession case is included as Exhibit F, Your Honor, in my index of exhibits. But that arrest occurred in Bear County on 1604 on February 22nd. And prior to any pretrial services violation report,
So the dismissal for Exhibit F is because of the office policy, correct?
That is the stated reason. I have previously known that there are multiplicity of reasons, and sometimes the stated reason does not seem in my mind to be the most important reason.
Okay, but everybody knows.
My understanding is that there were some arguments to be made on the merits, and if the case had to be fought as a misdemeanor possession of marijuana, that there were some defenses that might have caused my client to prevail.
And I should have clarified too, at the time of his arrest on the warrants, he was at a location he wasn't supposed to be for GPS. But, and that's stated within the violation report as well.
Which is Exhibit D, Your Honor.
Okay, so that's a problem. If he
That-
was at a location he wasn't supposed to be at, so.
That has already been penalized, Your Honor.
So let's get to the crux of the problem. So when he was arrested for the out-of-county issues that predate this offense, was he at a location where he was not supposed to be?
According to pretrial, yes, he was.
All
And
right.
that has already been penalized by the court in the increase in remanding him without bond and then increasing his bond, which the court did on April 11th.
Mhm. And
That was
so-
punitive in nature.
So why should I not keep him on full GPS?
Because, Your Honor, on April 11, you asked the defense to confer with the state. The defense did confer with the state. We were able to come to an agreement to $75,000 bond on each of the two sex assault cases, which was up from the previous 50, and all other conditions remain the same as before. The court remanded him without bond on February 24. That was the agreement that we made with the state. That was what the court signed when submitted with the agreed order. Exhibits G and H are the agreed order, which reinstated the conditions that he had prior to February 24, which specifically included partial GPS house arrest, because the most recent GPS order was dated June 16 of 2021, allowing him partial GPS for employment. So as soon as that agreed order was signed, he was back eligible to bond out, and then immediately upon bonding out, be on partial GPS. Now, between April 11 and April 28, he remained, or 27, he remained in Bear County Jail. But on April 27, his family was able to bond him out on the new conditions, which was $75,000 apiece plus partial GPS, with the understanding that he would be able to work and help pay the cost of his bond and his GPS monitoring. And then 2 days after him being released on bond, an order is handwritten on a B page, which is Exhibit J, suddenly placing him back on full house arrest with no violation.
All right, so here's my
On
question.
case number
What is
1804.
his work schedule? Because I'm not going to do any more of these issues where he just gets the floats around because he says he's an influencer.
I can answer that, Your Honor.
So I want
That's
a
not his work.
specific, I want a specific work schedule for him. And if he cannot provide a specific work schedule, then he is not going to be allowed to just float around.
We agree that he is not allowed to float around, Your Honor. Before he was rearrested, he was working with a temp agency. He was informing pretrial services of the schedule for the temp agency, and he was providing the documentation that they needed. And he's prepared to do that again, as long as he
But the
can provide the
problem
proof of
is-
employment.
But the problem is, when he was arrested for the marijuana, which was new, which is not out of county, according to what I'm being told by the state, and I haven't heard any objections to that, he was at a place where he was not supposed to be.
Your Honor, that has already been sanctioned and punished by the fact that he was remanded without bond, spent over a month in jail, and his bond was increased from $50,000 to $75,000.
I mean,
The
not really,
court
because
already
he-
dealt with that violation.
But we haven't specifically addressed that. What we addressed was the fact that he had out-of-county places, out-of-county warrants, which that predates this, and he picked up a new case and he wasn't where he was supposed to be. So this is the court's order. He is to provide a specific work schedule to pretrial services.
Okay.
If he does not have a specific work schedule, then he's not allowed to go. End of story. And I don't want, it's going to be, if he's working from 9 to 5 and he's working at a specific location, he needs to provide that the pretrial services. There's no more of this influencing business that's going to be going on. So if he has a gig where he needs to be, then if it's on the up and up, they need to provide him something saying that this is the time that he will be at his gig. And these are the hours and this is the location. If that cannot be done, then he can't be doing that.
Your Honor, I don't think we have a disagreement here. The main concern, the main reason for us raising this to the court's attention is that we had an agreement for an increase. That increase already encompassed the violations raised by pretrial services on the February
Okay, but if
23rd.
everybody can hear me, I'm going to give him partial GPS.
Thank you.
He's only allowed to work. There's not going to be any of this influencing business. If he wants to influence people, he can influence them at work with specific hours set.
We're in agreement, Your Honor.
And that will be that. Now, the
And-
next thing is, when are we doing a jury trial on these cases?
You set it for June 21st. The question that defense needs to get clarification on, there are a total of 4 felony cases, all of which are indicted. We need to know whether we need to have all of our witnesses in the bag for each of these 4 cases, all of which have different offense dates, or is it sufficient that we are prepared on the one that the state has stated that they intend to go on first, which is the 2021 CR 1804. We need to know if I need to have 4 cases worth of witnesses all under subpoena.
Yes.
Okay. We will, Your Honor.
Okay, is there anything else?
Nothing.
Nothing on the state.
Nothing further, Your Honor. Thank you for reinstating the partial GPS, and we will get documentation of work to pretrial services. We understand that each work assignment will be approved on a case-by-case basis as it fits into the format that the court has stated that it expects.
Okay, all right, thank you.
Thank you. It would be excused.
Yes.
Just may I approach on matter off this docket? So we had a case sent this for today, got moved to impact court. This is a motion to release a witness of ours that's currently in jail to the custody of one of our investigators to bring it to the DA's office to question him. And so,
Okay, why do you have Judge Angelini sign this?
so Judge, actually, I jumped onto a trial on the 186 today, kind of following Dan Rodriguez, who I was going to be trying this case against. And it just so happened that as I was in the 186, I got lumped into the trial for the state in 186. So I'm in a different trial now, but this one is now, I think it's still pending in impact court. Angelina didn't give a reset for today, so we still want to talk to this guy.
Okay, Angelina, still down there, okay?
He is not in this building anymore. He went back to the real impact court over in the basement of the civil. Okay.
All right.
Thank you, Judge.
I'm thinking about the right one.
All right, Brandon White.
Good afternoon.
Good afternoon.
Can I approach, please?
Yes.
Okay, Judge, Mr. White has 2 cases. Actually, the earlier case, which is the 2021 CR 11250, started off as actually 2 different incidents in the same indictment, one of which has been rejected. The other matter is an assault case. And so that was pending. And then he got indicted in January on an injury to the child case. On that injury to the child case, Judge, I have filed a request for an investigator. Plus, I've got about 500 pages of CPS records that just came in. And there's a child forensic interview that I need to go to the DA's office to watch. And so we were unable to reach an agreement on these cases, Judge.
All right, Ms. Ferguson, where are we on the trial? Mr. Brandon Marshall, is he up for trial? All right. So Ms. Ferguson, on Mr. Marshall, in each of the cases was an offer tendered, Mr. Cantu?
Yeah, yes, Judge.
All right.
Yeah, there was a package deal that was rejected.
All right, Ms. Ferguson, can you give me a 30-day reset on Mr. White, please? All right, Mr. Marshall, Brandon Marshall White. June 13th is going to be your plea deadline date. June 13th is going to be your plea deadline date. Do you understand?
Yes,
What that means is the court is not going to accept any plea bargaining agreements after that date. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Judge, would I be able to get an investigator appointed on one of the two cases?
If you have the motion, the court will sign it. Deputy Laura, Mr. White can go back.
Judge, if I could respectfully request Cindy Fisher to be appointed.
If she's on the list, do you know if she's on the list?
Yeah, she's done it before, Judge. I think, I'm not really.
Well, no, they print out a list of the approved investigators. I don't know if she's on the list or not.
Okay, I
'cause
can't
haven't looked
say.
at it.
Can I look into that? Because
Oh, sure, just go to the back and ask them. There's a list that's on the board in the back and just look at it and see if she's on there. If she's on there, of course, I have no issue with that.
Okay, thanks, Judge. He's the one I have a good working relationship with, but I'll go check. I'll be right back.
Sure, no problem.
We gotta hook up. Right. Yes. please. Yeah. I'll be back.
I'm pulling it up just to see. Information.
Yes.
Okay, yes, Your Honor. Okay, so the clerk didn't have a list, but I called Ms. Fisher to ask her.
Mhm.
She said she's on the. Okay.
Thank you. There should be a list like right on that board in the back.
I see.
What is your client charged with? Third degree felonies, correct?
Oh, yes. Okay, thanks, Jess. Have a good day.
Thank you, you too.
Been a long day, huh? Have, can I be excused after that?
Yes.
Okay, thank you.
Yes.
Judge Mayor, Pro Tem, 22 CR 0887 Rocha.
Yes, where's Mr. Rocha? All righty. Yes.
Judge, I believe it's set for a plea deadline. There was a new misdemeanor number 1 that I haven't had a chance to review all of the discovery. I don't think I've gotten it all yet. Good
Yeah,
cause.
today is his plea deadline day. So
I'm
is he
sorry?
today is the plea deadline day. Is he accepting the plea or no?
No, and that's why I was gonna ask, may I, for good cause, have an extension of like 2 weeks so I could review this new one to try to work out a package.
I'll recall it for Thursday.
Okay.
All right, Ms. Ferguson, Mr. Alejandro Rocha is coming back on.
Judge, how about the following Thursday? I just got so much going on.
I understand what you're saying, but it's gonna be Thursday, the 12th. At 9 a.m. Don't leave without a reset for your client.
Yes, sir.
Ms. Ferguson, Alejandro Rocha is coming back on Thursday at 9. Yes. Rudolph Montoya, who's Rudolph Montoya? Mr. Gross is coming. Okay. Oh, that's a great statement. So, Ms. Ferguson, on Montoya, do we have a setting for that already in the system? All right, thank you.
So I just want to leave the sticky with my client will be here. Okay. So I'll be running back and forth. So I just want you to know that I'm aware of that. Okay. Okay.
Bye-bye, have a great one.
Oh, it is Monday.
Bye.
Judge, I sent you a chat.
Okay, thank you.
I'll be right back.
Okay. All right, who do we have left on the docket?
He is the one that from County Court 9, the warrant. Salinas.
Oh,
Client.
so where is Todd McRae?
He was here earlier, and once he got a reset for the court here, he left. And Judge Saldana is not here.
Okay. Well, unless she usually gives bonds. All right, Mr. Salinas. Come forward, please.
I didn't use this for the previous offer, but.
Mr. Salinas, I'm going to go over your rights with you. I have no idea what the facts of this case are. I'm only here to tell you what your rights are. So out of county court number 9, I'm being told that you have a criminal mischief, $100 up to $750. You have a right to remain silent. That means you don't have to speak to anyone if you don't want to. You have a right to hire an attorney or have one appointed to you. If you need one appointed, there's a process. You'll have to fill out a form and they'll make a determination on whether or not you qualify for a court-appointed attorney. If you need help filling out that form, there's someone who will help you with that, and that will be one of the clerks. But you will need to swear, take an oath that that is true what you put in that form. You have a right to have an attorney present if you decide to make any statements to the police officers, peace officers, or attorneys for the state. Once you start speaking, or if you decide to speak to attorneys for the state or peace officers or police officers, you can stop or terminate that interview at any time. Whatever you say can be used against you in any other proceeding. Do you understand?
Yes, ma'am.
If you are not an attorney, I'm sorry, if you are not a citizen, if you're a foreign national, you have a right to have access to your consulate. Do you understand?
Yes, ma'am.
Right, do you have any questions?
No,
Are you gonna need a court-appointed attorney, or are you going to hire an attorney?
I'll need a court appointment.
All right, so with regards to court-appointed attorneys, you will be given one from the system. Once you're given that attorney will need to make contact with you the next business day. So if you're given a court-appointed attorney today, they'll need to make contact with you by tomorrow at the same time. You understand?
Yes, ma'am.
Are you able to make a bond?
Yes, ma'am.
All right, I'll set your bond at $100. I'll need you to sign that document. Your signature is not an admission of guilt. That signature is just to signify that I've gone over your rights with you, you understand them.
Yes, ma'am.
All right, good luck to you. Do we have anyone else left on the docket?
Joseph Acevedo?
I'm sorry, who?
Joseph Acevedo? I thought he just left. That was Alejandro Rocco.
No, it's partial.
You want partial?
Oh, no. This guy is full house arrest.
So just full house arrest. That's it, right?
Yes.
Because the attorney.
Oh, I could try, I just meant, I
No,
want him
no,
to have a
it's full
GPS
house.
monitor.
Yes.
You wanna do the scratch it off?
I just meant with GPS device, not that he'd be on full house arrest without it. but-
Yeah.
I'm sorry? We are? Oh, there's nothing left? Oh, do you have a date on Montoya? And who are you?
Victor Bettis,
Who's your attorney?
Natasha,
She's still in Valverde County, Judge.
Natasha Torres?
Yes, ma'am.
All right, is she trying the case there?
She was up for trial. I haven't heard from her, but she's.
All right, we're gonna recall your case for tomorrow. The court coordinator is gonna give you a reset form, okay? All right, with that, we are going to stop lunch and we'll be back on Tuesday.